Started. Again, good afternoon, everyone, and welcome to today's webinar. My name is Michelle Peterson, and I'm the training manager for the Empire Justice Center. First, I do need to note that today's webinar is made possible by the New York State Attorney General Homeownership Protection Program and in partnership with Legal Services NYC. Before we get started, just a couple of notes on how you can interact with us. Everyone has entered the webinar in a listen-only mode. If you have any questions on the material that's being presented, you can enter your question using the questions pane located on your control panel. We'll be addressing questions both during and at the end of today's presentation. The materials for today's webinar can be downloaded by going to the handouts pane, which is also located on your control panel. Here you'll find a copy of today's PowerPoint and an additional handout along with the attorney affirmation form, those being CLE credit. Today we're going to be providing 1 credit in the professional practice category. So to receive your CLE certificate, note the verification code on your attorney affirmation form when we announce it, and send your completed form to my attention. I'll also put the CLE verification code in the chat box, which is on your control panel as well. For any non-attorneys looking for a certificate of attendance, we can provide that. You'll have to send me an email to request your certificate. And finally, at the end of the webinar, you'll be asked to complete a webinar evaluation. So please take a moment to complete that. We appreciate your comments. With that housekeeping out of the way, I'm going to turn it over to our moderator, Becky Tyko.
Thanks, Michelle. So today is really part 2 of a 2-part series. And the first Wednesday, when we talked about essentially the first 3 parts, or 3 out of the 4 parts of the new legislation that was passed back in June. So Jay Inwald has agreed, thankfully. We haven't had him as our primary presenter in a couple of years now, so it's nice to have you back, of course, in this capacity. But we are going to be talking about the components of this legislation that really impacts our day-to-day work. And so without jabbering on any further, Jay, as always, thank you.
Thank you, Becky, and thank you, Michelle, for hosting this webinar. So I'm going to go through, to the extent that I can, in an hour in as much painstaking and tedious detail as I can, the various changes to the settlement conference law and the predicate notice law for residential foreclosure cases in New York. These are really significant changes. They perhaps are not as highly publicized as all the zombie foreclosure laws that went into effect. But from our perspective, representing individual homeowners in cases, they're really significant, and for the most part represents many of which many of us have been advocating for quite a while. There's also, as was alluded to, you have an article that I did that provides some of this information in a little bit more detail with a little bit more narrative. I just wanted to say before we start, it's really important for us to internalize and these various changes and really press the courts to enforce these changes. This will not come to them naturally. The feedback we're getting, in fact, is that many members of the judiciary are extremely hostile to these changes. So it's really incumbent on us to insist that they actually comply with the law. The other thing I will just say is these changes basically become effective on December 20th, 2016, which is, in some respects, might be viewed as a holiday present for us, but it is also not on many of us that the irony that these changes are going into effect literally days before HAMP expires. So with that, I'm going to move us along and try to see if this PowerPoint will let me go to the next page. So here we go. So this, don't need to dwell on this. Obviously, we've covered last week all the changes governing zombie properties, and we're going to be focusing today on the settlement conference law and the 90-day notice changes. So the first thing to note is that the actual scope of the settlement conferences as they're defined in 3408A has been clarified. many of you were probably familiar with the phenomenon whereby some courts were using their perception of loan modification eligibility to screen people and prevent them from even getting into settlement conferences. And that was because we had a statute that actually expressed a preference, which was a good thing, for loan modifications as the desired solution. But we also all know that there are homeowners for whom a loan modification isn't the solution that they need. It might be a deed in lieu, and it might be something else, a short sale or something, or who knows what else. So although we had already secured amendments to the Uniform Court Rules, making it clear that settlement conferences were not just for loan modifications, many courts proudly disregard the Uniform Rules and don't think that they really have to follow them. So we now have it embodied in the statute that it is not just for loan modifications, and the courts really have no basis for taking it upon themselves to screen people out of conferences. So that's a positive development. So let's talk about the changes in language governing authority to settle. Many of you know several years back we did a report based on observations in New York about how rampantly plaintiffs disregard the existing requirement to come to court with authority to settle. So there are some tweaks to the language governing that now, which perhaps will give us more ammunition to urge the courts to enforce that requirement. It now says whether an attorney or a representative, whoever is coming on behalf of the plaintiff, has to have authority to resolve the case. It also addresses an imbalance that used to exist in the statute. The irony was that the statute contemplated that the court could allow a plaintiff who had made the voluntary decision to commence a lawsuit in our courts the option of not having to appear in person if the court were to give them permission, but it didn't actually contemplate allowing that accommodation for defendants who didn't choose to commence a lawsuit and for whom it might actually be necessary to lose work or tear themselves away from other obligations to appear at settlement conferences. So although I'm not aware of terribly many courts actually granting the authority to appear completely by telephone, it satisfies me at least a little bit that there isn't that imbalance in the statute. So that's an improvement as far as I'm concerned. Again, there are important changes in the recitation in the statute about what information people have to come to court with for settlement conferences. And this is significant, first of all, because the prior language was kind of useless because it said the plaintiff should bring such and such. It now has language that says shall, so that mandatory aspect of it is pretty significant. And it goes into additional detail about what the plaintiff is supposed to bring. So in addition to the payment history and the mortgage and the note, or copies of the mortgage and the note, the statute requires the plaintiff to come with standard application forms and a description of loss mitigation options, if any. So what the courts are going to make of that is a little unclear, but it does require them to have a little transparency, and there's a more detailed specification of what plaintiffs have to come to court with when there are already pending loss mitigation applications. So they are supposed to be able to provide us the summary of the status of any pending applications, a specific list of outstanding items, the expected date of completion of the evaluation, if there are any pending evaluations, and if an application has been denied, a denial letter or any other document explaining the denial, including the data input fields and values used in the net present value calculation. Of course, how much net present value calculations are going to be happening after December 31st is an open question. The other thing that's in there now, which didn't used to be there, is if it's denied based on an investor restriction, they are required to have the documentation of such restrictions, such as pooling and servicing agreements. So we all know that much of the litigation around 3408, in fact, has revolved around, refusal to document investor restrictions or to seek waivers. So this is helpful that this is now spelled out there.
Jay, can I? So this is Becky. So last week, oh, sorry, my headphones are off. Last week, or maybe 2 weeks ago now, I was with the upstate training for the judges out in Syracuse, and the conversation around documentation that needs to be brought to that first settlement conference, the judges and the court personnel acknowledged that that was not something that regularly happened now. However, they did seem to acknowledge that it was still important for those documents to be brought, and so they seemed to be inclined, as best as you can generalize this with 130 people in the room, that the first conference, what we call the first conference, they're not really going to capture that information at that first conference, but that first one is almost like a preliminary meeting, and that they're going to then expect these documents to be brought at really the second conference. But that was sort of seemed to be the general thought in the room.
Well, that's helpful information. I think different courts have different procedures, so it's going to play out a little differently, I would imagine, in each courthouse. But the main thing is we have this, I'm not that perturbed if, this is something we're going to be able to press them on at the second conference rather than the first. So many homeowners are showing up on their own for their first conference and haven't services yet. So, that's, I think it's still a positive that we have this there, and the fact that they're at least willing to consider enforcing this requirement even at a second conference, I think, is helpful. I wanted to also point out that there is additional language on what is required of defendants with respect to what they have to bring. And it's important to parse this language because there was a lot of conversation and discussion about codifying a requirement that defendants be required to bring their actual tax returns with them to court. And many of us were not really thrilled with that being in the statute. And it's problematic on many levels. So what's the compromise language that's in there, which I think people should be aware of, is that they're required to bring information on current income tax returns. It doesn't actually say bring their current income tax return. So that was, I think, put in there to give homeowners a little bit of wiggle room on that issue. And what exactly information on current income tax returns means, I'm not exactly sure, but I wanted to just flag that.
And then I'm just going to flag, Jay, Aisha Baruni, who was a trainer at the New York City event just a couple of days ago on Monday, and she acknowledged that the downstate judicial staff seemed to be more concerned that the borrowers will not be bringing in the documents required. Seems to be implying what Aisha is saying is that less concerned about the plaintiffs, which is a crucial part of the conversation, of course, but more concerned about the borrowers.
Yeah, well, that's I'm sure that's true. But be that as it may, we have what's in the statute now, so we've got to press the courts on this. It'll be really interesting to see what the judges who weren't and what the referees who weren't at these trainings will be doing as well. So in any event, let's move on to the subject of good faith, because again, I'm sure most of you know, a big challenge that we've had in the past is that although we had a statute that imposed a good faith negotiation standard, it didn't actually define what good faith means and it left us to be litigating that issue with mixed results depending on what court you were in and what appellate court you might have landed in. The statute adopts now some of the language that has evolved from the case law. It specifically says that good faith negotiation is measured by the totality of circumstances, and I think the totality of circumstances is language which gives us a lot of room to argue for lack of good faith, but it actually goes through multiple factors which are possible indicia of lack of good faith. So the obvious one is compliance with court rules and directives. So you've got a very strong argument that if the court has, directed anyone to come to the next conference with X, Y, or Z, if they don't do that, that's certainly one indicia that there was a failure to negotiate in good faith. The next one is compliance with mortgage servicing laws, rules, regulations, investor directives, and loss mitigation standards. So this is generally positive because I think it gives us room to argue that although HAMP is going away, obviously this would have contemplated that non-compliance with HAMP requirements is an indicia of failure to negotiate in good faith. But it also gives us room to argue that the New York State Department of Financial Services Part 419 mortgage servicing rules, which has lots of requirements in them that servicers are known to violate, would also be indicia of failure to negotiate in good faith. Now, I do want to point out that there's language that crept in there at the insistence of the banks. You'll see the word investor directives, right? So we didn't ask for that language to be in there, but that was put in there to placate the banks. So that's going to give them some ability to argue that compliance with investor restrictions and things like that is, shows that they are negotiating good faith. So I just want to, point that out to people. And then, of course, there's general language about conduct consistent with efforts to reach a mutually agreeable resolution, avoiding unreasonable delay, appearing with authority to settle. Now, that's really, this incorporates the requirements of, of coming to court with authority to settle, and I think that gives us some really good arguments to make when there's a repeated pattern of coming to court unable to do anything. That in and of itself is now codified to be one of the indicia of failure to negotiate in good faith. And here's the other thing that I want to point out. There's a specific reference to dual tracking in addition to providing accurate information to the court. So why is the reference to dual tracking significant? So here's why I think it's significant. We've had a lot of issues with courts being unwilling to even consider tolling interest for periods predating the start of the settlement conferences. So they've, if there were all kinds of abusive things that took place before settlement conferences took place, and obviously we know that all of the same type of stuff happens when people are trying to do loan modification applications on their own, even before they get to court, as happened, once you're in court. And I've seen many courts just be unwilling to even talk about what happened before the formal start of settlement conferences. So dual tracking, by its definition, really contemplates conduct that took place before the case started, right? So I feel like this gives us permission to argue for relief and for consideration of conduct that took place even before the case was in settlement conferences and arguably before the case was even commenced. So, so that's, I think, an important point to be aware of. But, of course, there is also language that was injected there to placate the banks, saying that failure to make or accept a particular offer is not in and of itself sufficient to establish the absence of good faith. And that's fair enough. The courts have generally held that anyway. And the language is sufficiently balanced that it also protects homeowners who can't be accused of failing to negotiate in good faith just because they didn't accept an unaffordable offer. So I think on balance, again, these are all positive changes. So
Jay,
one of the other...
Jay, can I interrupt you again?
Yes,
okay,
absolutely.
So first one I think you might get into a little bit later on, but just to be clear, will the court be communicating to the defendants the new documentation requirements? And I think this is an example, perhaps, but will it appear in the appearance notices for court conferences?
So that's a good question, and I think the answer to that is what I was describing on the earlier slide about the information that the parties are required to come to court with. The way the statute is worded, it actually talks about the court shall provide notice to the homeowner of the settlement conference, and the notice is supposed to specify the new information, the information that they need to come to court with. So, in theory, and I haven't seen, any new notices that the courts are sending yet, but yes, that is supposed to be in the written notice of the scheduling of the settlement conference to the homeowners.
Right. I can tell you that certainly in upstate, I think many of the courts, they have included the language that's in the current language of the statute, and they seemed to indicate that that was going to get updated accordingly. So yeah. Probably, yes. Okay, so the next question is has to do with in regards to the court no longer taking it upon themselves to screen for loan modification eligibility, and therefore ultimately depriving conferences for short sale or deeds in lieu. Does that then mean that the court cannot release a case from settlement conference if the borrower first applied for a modification and was either denied or offered one that was not affordable, and as a plan B wants to now go for a short sale or a deed in lieu? Does that plan B remain in settlement conference until resolved?
So I don't know that the statute answers that question explicitly, but I would think that you would certainly have room to argue that a negotiation is a process, and if it's clear that one loss mitigation option is not going to work, but that there are other options that the homeowner is trying to obtain, that good faith negotiation would require. And in other words, there's certainly nothing in there that says you get one bite at the apple, seems to me. But I don't think there's anything specifically that you can hang your hat on, other than sort of there's an obligation to negotiate in good faith, and if one solution isn't proving to be workable and there's another proposal to work towards, I would certainly think there's room to argue that you shouldn't just get bounced out of the conference, conferences because there are other solutions that are contemplated. And so
I would say it's an easier position to take if that whole application and denial or decision not to accept an offer potentially, if that happens prior to settlement conference, and now they're saying I'd like to pursue a short sale. That seems like a very simple, straightforward argument to make, and I suspect the courts will be perfectly fine with that. But whether they're willing to keep it in for that whole process of getting an application, getting a denial, or not interested in accepting it, but wanting to pursue a short sale, that's certainly worthy of an argument, but it'll be unclear. The courts do have their standards and goals that they are very interested in maintaining.
Right. Well, that's definitely true.
Yes.
So
perhaps over the course of instead of justice. So regardless. So what exactly does dual tracking mean? Can you summarize that in a sentence?
Okay. So dual tracking is sort of the colloquial term that was applied to the phenomenon of banks entertaining loan modification applications and accepting paperwork and even perhaps asking for follow-up documentation, but at the same time going ahead and filing a foreclosure action. And that's, I mean, does that?
I think that works.
That's basically the definition. Do you have a better definition?
No, I think that works. Yeah, no, I think that works.
Okay.
Yeah. That's it.
Okay. So I'm going to go on unless there's other questions about some of the aspects of procedures relating to good faith motions in settlement conference cases, because again, many of you are probably aware that this has been sort of a free-for-all, and there's been really a lack of clarity about what, A, the extent to which the courts can even entertain such applications, and B, how they should be entertained. So there's a little more clarity now than we used to have. And to the extent that you had courts and certainly litigants, plaintiffs arguing that the court has no authority to even impose any kind of relief, that's not going to fly anymore. This is very explicitly laid out. The statute now very explicitly says that the court may determine good faith negotiation and order remedies either on motion or sua sponte on notice. So it's clear, like, if the court is going to do it on its own, and we've had this problem with some courts where they actually didn't give any advance notice to the plaintiff that they were entertaining such relief. So now it's clear that the court can do it on its own, especially, and this is important for people who are unrepresented, but if they do that, it has to be on notice. And it authorizes the Office of Court Administration to establish procedures, and it specifies now that the referee, the judicial hearing officer, or other court staff designated to oversee settlement conferences may hear and report findings of fact and conclusions of law, and may make reports and recommendations for relief to the court concerning failure to negotiate in good faith. It does not specifically say that an evidentiary hearing, a trial, is required. Hear and report can mean, in my view at least, that the referee can hear oral argument, especially if it's the same referee who's been presiding over the conferences and really knows what's been going on in the first place. So this is important clarity that it's clearly contemplated that there can be a process when there's been a failure to negotiate in good faith. And then, of course, the other thing that was totally missing from the statute was a specification of the remedy for failure to negotiate in good faith. And over the years, we got it established by way of case law that, tolling interest is the most logical remedy. And we now have the statute saying that at a minimum, if it's the plaintiff that's been found to have failed to negotiate in good faith, tolling of interest, fees, and costs during any period of undue delay is an appropriate remedy. And there are other specified as well. So compelling production of documents, for instance, if you have someone who's refusing to divulge a pooling and servicing agreement, something like that. There's actually a provision for a civil penalty of up to $25,000 to deter similar conduct. That's a penalty that goes to the court, not necessarily to your clients, but still, that certainly should have some deterrence effect. And any other relief the court deems just and proper. The relief, if it's the defendant who's found to have failed to negotiate in good faith, is generally contemplated to be removal from the settlement conference calendar, meaning that the case can go forward. But there's some helpful language because in making a determination that a defendant has failed to negotiate in good faith, the court shall consider equitable factors, including whether the defendant was represented by counsel. So in my view, that is important recognition of the disparities that present themselves at settlement conferences, where so many homeowners don't have access to counsel and should perhaps not be treated as harshly as lenders and servicers who have a lot of resources at their disposal. So here is another major change that we now have in the law, which came in through the settlement conference law, but it really addresses the problem that many of us experience with homeowners reaching us only at the settlement conference stage of the case, long after the time for putting in a timely answer has been passed. And many of you have heard me lose my cool with each horrible decision from the second department on the subject of what constitutes a reasonable excuse for failure to put in a late answer in the context of foreclosure cases, where many of the appellate courts just apply a completely different rule of law for foreclosure defendants than they do in any other context. So we've really, I think, achieved some significant improvements for our clients in this regard. We now have an explicit provision that obligates the court at the first settlement conference, if the defendant has not filed an answer or a pre-answer motion to dismiss, to advise the defendant of the requirement to answer the complaint, to explain what answering a complaint in court entails, to advise the defendant that the ability to contest the foreclosure and assert defenses may be lost if the answer is not interposed, and to provide information about available resources for foreclosure prevention assistance. We additionally have a new subsection M, which really overrules much of the appellate case law, which effectively barred non-answering defendants who participated in settlement conferences from vacating defaults and interposing answers. It provides that a defendant who has defaulted in answering but appears at settlement conference is presumed to have a reasonable excuse for the default and shall be permitted to serve and file an answer without any substantive defenses deemed waived within 30 days of the initial appearance at a settlement conference, and with the defendant's default being deemed vacated upon service of that such a late answer. So I am cautiously optimistic that this is really going to represent a sea change for a lot of clients who will now hopefully have an opportunity to preserve their defenses by putting in an answer. The courts are very much aware of this provision. I know some of them are hostile to the idea, but OCA, I understand, the Office of Court Administration, I understand, has come up with what they are calling a bench card, which is supposed to be a script, which basically would be a uniform script that the courts will provide to homeowners at their first settlement conference, and hopefully this will work in conjunction with legal services providers, at least in some courts, who are able to come up with some way of getting to homeowners at these first conferences so that they can help them put in pro se answers and preserve defenses. That's going to play out differently in different courthouses, and there's going to be a question about what constitutes the first settlement conference, because where there are sort of initial screening conferences and pre-conferences, and some of those details remain to be seen. But in my view, this is a pretty significant sea change, and it really requires work from us. But I think this is a positive change.
Okay. Jay,
was there a question?
Yeah, there's a couple of questions. So first of all, I missed when it came in, and I'm sorry. The question simply is, this is a non-rebuttable presumption, question mark. I missed where that was referencing.
Is that referencing, perhaps it was referencing the language that's now there saying that they are presumed to have a reasonable excuse for the default. So I guess that's something that could end up being litigated. It's not explicitly addressed in the statute, but I think what this is really giving expression to is the preference for resolving cases on the merits, and trying to have a little bit more recognition of the facts on the ground, that homeowners don't understand the need to put in a late answer when they're first served with a complaint, and that if they're actually showing up and trying to save their home at settlement conferences, they ought to be given an opportunity to put in an answer. But I can't answer the question whether it's going to be viewed as a rebuttable presumption. And I guess I'm not sure what you would rebut that presumption with. But that could actually be something that I guess that gets thought about.
Okay.
Were there any other questions, Becky?
One more, yes. So the question is, could 3408M help plaintiffs who fail to answer counterclaims? I'm assuming that they fail to submit, fail to include in their initial answer counterclaims? I'm not sure.
I'm not sure I'm understanding the question. I think the question, in other words, is the question about a defendant who actually had put in a timely answer with a counterclaim and the plaintiff?
That's what I'm assuming. Yeah, I'm trying to read it. It said yes. So yes. So the defendant who files an answer and they fail to include counterclaims. I think that's probably what makes more sense.
So I don't think it's really going to speak to that, because this is really comes into play if there hadn't already been a timely answer by the defendant. So I don't really see this as giving some sort of new opportunity for a plaintiff who failed to respond to a timely answer that included a counterclaim. That's not to say that I just don't see it flowing from that.
Okay, that's it, I think, for now.
Okay, so the other part of the legislation that's implicated right at this point is there's a new provision of RPAPL 1303-3-A, which provides for a consumer bill of rights, which is required to be provided to the defendant at the first settlement conference as well. So that provision charged the Department of Financial Services with publishing a consumer bill of rights in consultation with all stakeholders, which shall detail the rights and responsibilities of the plaintiff and defendant in a foreclosure proceeding, and it's required to be updated on an annual basis as appropriate. So the Department of Financial Services, we happen to know, is working on that, and advocates have provided some input on the kinds of information that people think should be in there. I don't put huge stock in the impact of these kinds of information, but it's certainly better to have it than to not have it. So it looked like the initial draft that the Department of Financial Services shared seemed to be more focused on the rights and responsibilities of the defendant in a foreclosure proceeding, and didn't provide all that much emphasis on some of the obligations that are on the plaintiffs. So I'm hopeful that they'll take some of the input that's been provided to them on making some of that a little clearer. But again, this is something that is supposed to happen at that first settlement conference. This new provision N says that motions shall be held in abeyance while the settlement conference process is ongoing, except for motions concerning compliance with this rule and its implementing rules. So this codifies what was already supposed to be existing practice under the uniform rules, but there were some courts that were making it difficult for parties to actually seek relief for failure to negotiate in good faith unless the case got released from settlement conferences. So this now makes it clear that good faith motions are contemplated even while the cases remain in the settlement conference part. This is just an improvement to 3408G, which used to require the plaintiff to file a notice of discontinuance and vacator of the lease pendants within 150 days of any settlement agreement. It now requires that that be done within 90 days. And I just wanted to point out that it still remains the case that it's unlawful under 3408H to charge for costs or attorney's fees for appearance at or participation in settlement conferences. So, oops, that was not what I meant to do, sorry. So now we're going to, unless there are more questions about the subject of settlement conferences, I'm going to move on to the changes in the various predicate notices. So just to give a chance, any settlement conference related questions?
No, but there's a comment that I think might be helpful. So some downstate judges seem to be suggesting that the information package, including in the Consumer Bill of Rights, will be mailed to the borrower instead of providing at the first conference. So advocates should be on the lookout for that. And the idea was shot down by presenting judges, but the fact that some judges thought it would be acceptable is worth being on high alert about. That's it.
Yeah, that's a good point. I mean, I have no problem with providing the information more than once. So if it's provided when they get their notice of settlement conference, I think that's just fine, but it shouldn't be to the exclusion of getting it in court as well. That's just my own personal opinion. But so we should all be vigilant on that. Yeah. Anything else on settlement conferences before I move on?
I'm going to bring the other questions to the end.
Okay. Okay. So now let's move on to the predicate notices amendments. There are changes to the 90-day notice, RPAPL 1304, and the help for homeowners and foreclosure notices, RPAPL 1303. As I'm sure most of you are aware, both of these notices are conditions precedent, and if they are not strictly complied with, you've got grounds for a motion to dismiss. So that law is not changed at all. There are changes to both the language of the 90-day notice, which is actually prescribed in the statute, and there are other changes to the law surrounding 90-day notices. So updates to the language, which are designed to better provide borrowers with notice of the amount required to bring the loan current, and also to be consistent with CFPB mortgage servicing rules around dual tracking. So there's clarification that the requirement is applied to borrower or borrowers, plural, whether at the property address or any other address of record. The language of the notice is slightly tweaked to try to better communicate the amount that's required to bring the loan current. And there are changes to the language in light of the prohibitions on dual tracking. So it used to say that if the matter is not resolved within 90 days, the plaintiff can bring the action. It now says if you have not taken any actions to resolve this matter within 90 days. Because if in response to a 90-day notice, a borrower actually submitted a loan modification, the CFPB rules would have prohibited moving towards foreclosure. So this was meant to address that issue, although I'm not sure it's a perfect solution to the problem, but we'll see how that plays out. This is, again, among the major changes to the actual language of the notice, and it's kind of related to all of the issues around vacant and abandoned properties, because many distressed homeowners would get their 90-day notice and really have no understanding of what its significance was, and might actually even interpret it as an eviction notice or worse, and would just give up on the house right then and there and leave the houses abandoned. So there's much improved language now explaining that the homeowner has the right to remain in the home. In fact, it makes it clear that they have the continued right to remain in the home until they receive a court order telling them otherwise. It explains that even if a foreclosure action is commenced, they have the right to remain in the home, and that the homeowner actually remains the owner of the home and is responsible for the home and the associated obligations of homeownership, sale of the property following a foreclosure. And it very explicitly explains that it is not an eviction notice, and indeed that a foreclosure case has not even been commenced yet. So that's, I think, a significant improvement to the language of the notice. The other things that were done to the text of the notice were meant to address the fact that when this was originally enacted, there were different sources of information about housing counseling agencies, and so this has been tweaked somewhat to provide more current information about where the resources are available and where they can be found. I'm not sure that I really need to say much else about that. But I know it's still a challenge to actually come up with a list of 5 housing counseling agencies in many locations. But the bottom line is at least it's updated somewhat at this point. And this I also wanted to focus on because there was some strange language in the previous version of the 90-day notice, which made it sound like you were excused even serving the 90-day notice requirement in cases where the borrower had made an application for what was called an adjustment of debts or an order for relief from the payment of debts, which is very archaic terminology which most people understood to mean bankruptcy. But we had at least one judge who decided that that language meant that if you had ever applied for a loan modification, you were not even entitled to a 90-day notice at all, which of course makes no sense and is antithetical to the whole regime, which is meant to encourage people to apply for loan modifications. So we've gotten that individual judge legislatively reversed, at least as of December 20th, because we now have the language updated to refer to filing for bankruptcy protection under, and it also makes it clear that that carve-out only applies to the 90-day waiting period before filing the foreclosure. It doesn't mean that you don't have to actually serve the 90-day notice, and there's even language specifically saying nothing herein shall relieve the lender of the obligation to send such notice, which notice shall be a condition precedent to commencing a foreclosure proceeding. So it's a narrow issue, but for those who are dealing with that particular judge, it's an important one. Also an improvement is, although we still have the language that says that the 90-day notice, that the 90-day period, the 90-day notice need only be provided once in a 12-month period to the same borrower in connection with the same loan and same delinquency, we now have language that says should a borrower cure a delinquency but redefault in the same 12-month period, a new 90-day notice is required. And this is pretty major, and this is pretty novel. We now have a language access provision incorporated to the 90-day notice requirement for any borrower, quote, known to have limited English proficiency. The notice shall be provided in the borrower's native language or a language in which the borrower is proficient if it is one of the 6 most common non-English languages in New York based on U.S. Census data. And the Department of Financial Services is charged with posting the notice on its website in those 6 most common non-English languages. So some of you will note that this is ostensibly or arguably triggered by the borrower being known to have limited English proficiency, and you can imagine that many lenders are going to take the position that they have no idea what language their borrowers are proficient or not proficient in. Although if I were, so I could see litigation around that in theory, but I think it also is fair to argue that any sane lender would want to avoid an issue around that, and since they're getting the translations done for them for free by the Department of Financial Services, why not just automatically include the language in the notice in all 6 languages every time? Admittedly, that kills more trees, but if I were a cautious in-house lawyer counseling a bank, that's what I would recommend. I'm going to move on to the 1303, the notice accompanying the complaints themselves. the Help for Homeowners in Foreclosure notice, there are similar changes to the language, although they don't track exactly the language in 1304, but they're also meant to make it clear to homeowners that they are not required to vacate just because the foreclosure case has been commenced, that they have the right to remain in the home until the property is sold at auction after judgment of foreclosure and sale, and cautioning them that they remain responsible for maintenance of the property and payments of property taxes, whether or not they vacate the home after commencement of the foreclosure action. So again, those will hopefully at least alleviate some of the issues around vacant and abandoned homes that are generated by homeowners misunderstanding the notices that they get or the significance of having been served with a complaint. So I think that brings me to the end. Well, I actually repeated the same slide twice for some reason. Don't ask me why that happened. We're, I guess, more or less on schedule or ahead of schedule. So if there are other questions or other comments from those online, I'm happy to turn things over.
So there's 2 questions so far, and then we'll see what kind of rolls in at the end. So the first one has, what if defendant had filed an answer pro se and now finds out as a result of the new attention to this subject by the courts that their answer was not filed correctly and did not include defenses that are available, that are present? Could they be allowed to do an amended answer?
So that's a good question that I don't think is explicitly contemplated by the legislative amendments. But, oh, sorry, I didn't mean to hit my mouse. But my response to that would be, it's always been the law that someone who's already put in an answer can make a motion for leave to amend. And the standard for amendment is pretty liberal. And in fact, if you satisfy the standard for amendment, which is basically that it doesn't cause any prejudice to plaintiff, and you'd be hard pressed to imagine that there has been any prejudice if this is happening, for the first time at the first settlement conference. They should be permitted to amend, and in fact, they can do so even to assert defenses that would otherwise be deemed to have been waived. There's a Second Department case called Sharif, S-H-A-R-I-F, that specifically allowed for amendment for purposes of asserting the standing defense, which would otherwise have been waived because they had already put in an answer. Now that would, of course, require some assistance because it would require this. There would be nothing stopping a party from just asking at such conference for permission to put in an amended answer without having motion practice, and I could see perhaps some, if you had a judge running the conferences, perhaps just like, directing the plaintiff to consent to an amended answer. But short of consent, I think they would need to make a motion for leave to amend, which could probably be done with some sort of pro se assistance, I would imagine. That's the kind of motion that, I wouldn't have too many compunctions about sending a homeowner in with a pro se motion for leave to amend.
Right. Okay, so one more question so far. Let's see. The requirement that the motion to discontinue be filed within 90 days, does that require that a fully executed loan modification agreement is provided first?
I think that's what it's based on, the signature, I think. I'm actually trying to look at the statutory language right now, because the only thing that changed was the number of days. They didn't change anything in terms of what actually triggers it. And I think what the question is getting at is the issue of waiting for a countersigned document, which is often a challenge. I'm not sure I have a good answer to that other than the fact that all this has done is changed the number of days. I don't think it's changed when, but I'm just actually trying to find it in the statute. So I don't want to waste people's time while I'm looking through this, but
yeah, I will just butt in. I'm not looking at the statute right now myself, but just as a second opinion, I suppose, I didn't think that the language changed. It certainly didn't make an issue of that. It has been an issue for those of us practicing in the field, but it hasn't been directly addressed
yeah, I don't think the statute addresses that issue. I don't think it's been addressed.
Right. So another question here, RPAPL 1303. Shouldn't it go further in advising that the homeowner can stay in the property until served by the new owner, or will this be addressed by the courts in their new instructions to the defendants? So we actually have the language. I have not spent much time looking at it yet, but we actually do have the language, Jay, from the courts.
Yeah, I haven't seen it yet.
It was in a packet of materials they handed out to everybody, which I don't know if you have gotten that yet, Jay, or not. But
I haven't gotten it yet. I've been promised that I will get a copy of it, but I haven't seen it yet. So regardless of what the language says, I mean, the bottom line is, and I know this is something we tried to address in our comments to the Department of Financial Services on their Homeowners Bill of Rights, because they had very imprecise language that suggested that the homeowner has to vacate, once there's been a judgment of foreclosure and sale, or if there's been a sale. And that, of course, is not really true. You don't really have to, leave until they've actually commenced an action for possession, most typically in housing court. And then until you get a warrant of eviction. But what the court is actually willing to say about that, I'm not sure.
Yeah, I seem to recall it being a bit vague, but at some point, maybe what we can do is we'll send around a copy, as a work group list or something, of what the courts are planning to distribute, or what they have distributed, rather, to their personnel in terms of what they plan to be, what's their little note card saying and all that.
Right. So I want to go back to the previous question about the 90 days. I'm sorry it took me a while to isolate the provision in 3408. It's 3408G. Technically, what it says is the plaintiff must file a notice of discontinuance and vacator of the lease pendants within 90 days after any settlement agreement or loan modification is fully executed. So that should be, from the return of a countersigned document.
Right.
And I think in general that's to our client's benefit. We want to still have the ability to go to court and complain if we're not getting the countersigned mod back.
Yeah, absolutely.
So.
Okay, so another question, let's see. Do the changes apply to cases currently in settlement conference?
So that is actually a really, I actually have to go back and research that. I'm not sure that that's specifically addressed. I don't think it says that these changes only apply to cases commenced after the effective date. I think it's going to be applicable to any cases, certainly any case that gets into its first settlement conference after December 20th. But I would, frankly, if you're talking about the further definition of the good faith negotiation standards or the procedures or whatever, I would, without even obsessing over what the statute says about its effective date, I would argue for applicability of the substantive requirements. We're not going to get these new first conference procedures to be implemented retroactively in conferences. But if we're talking about, what is good faith negotiation and what are the procedures applicable, I would argue that this is going to be applicable, but I have to admit that parsed what these amendments say about when they actually, I mean, it says this actually take effect on the 180th day after it shall have become a law. So that's really what it says, although there are other bizarre things in the effective date that says that aspects, the amendments to 3408 actually revert to the way they used, 3408 will revert to how it used to be upon the expiration of the extension of 3408. That requires a little bit of background to understand what I'm saying, but a few years ago, the law that extended settlement conferences to all categories of home loans when they were originally only available for subprime and high-cost loans, we got a 5-year extension of that change in the law. I'm going to be like that Steve Martin character in the movie The Jerk. The new phone books are here. The new phone books are here when my new CPLR comes. But that's as best I can do on that question.
So I'm getting a little pop-up here that says our network connection has been, that it was lost at some point. So for those of you, I don't know if there was any break in the audio. I'm sorry if there was. But if you have follow-up questions, you're welcome to give, I'm going to volunteer you, Jay, welcome to give you a call. If you're upstate, you'd rather give me a call, I'm happy to chat. We both spent a considerable amount of our lives over the last couple of months getting to know this language, so we can help you as best we can. On a side note, when it comes to just the mechanics of today's presentation, there was at least one person who said they were not able to download one of the documents that was included in the presentations today. If you were also one of those folks, please make sure that you let us know so we can email it to you. I believe, other than the PowerPoint, I believe that the other two documents, they were at some point circulated amongst the various listservs. So I'm not inclined to redistribute those again, but if you did not receive them and you would like them, let us know and we'll get them emailed to you directly if you were not able to download them. Also, just to make sure that folks know the code, where did it go? The CLE verification code is J, as in Jack, 84820, and you can find that in the little chat box in your dashboard there on the side of your screen. So with that, thank you as always for your help and your attention to detail in the statute, and to everybody else, thank you and have a good day.
Thank you.